Members, it's the appointed time and we have a quorum. First of all, Happy New Year. I wish you all good health. Thank you for attending this meeting of the Bills Committee on Inland Revenue Amendment Tax Deductions for Assisted Reproductive Service Expenses Bill 2024. The government officials are just outside the room. Let's invite them in. While we wait for them, I'd like to consult members on this. It's about whether we should invite public views on this matter. Regarding this bill, if members find it necessary, this Bills Committee can post a notice on the LegCo website to invite members of the public as well as the 18 district councils to attend public hearings or provide written views. Members, what do you think? Yes, Ms. Nixie Lam. I think it's great to invite members of the public to provide written views. I support the collection of written submissions. Any other views from members? If we all agree, we will invite the public to provide written views. And those views will be passed to the administration for reference and consolidated reply. We all care about government's policies on promoting fertility and childbearing. Before we move on to the clause-by-clause scrutiny, we'd like to have a discussion on the policy matters. Let's invite the administration to walk us through the bill first. Thank you, Madam Chair. To cope with an aging population as well as a low birth rate, the Chief Executive in his 2023 policy address announced an array of measures to promote fertility. We understand that couples facing difficulties in conceiving may need to make use of AR services, assisted reproductive services, to achieve pregnancy. Currently, it takes time for people to get public services. And these services may also pose financial burden on those in need. Therefore, we have announced two measures. The Hospital Authority will gradually increase the number of AR service quotas to reduce the waiting time for public AR services. Also, we propose tax reductions for expenses on AR services for those who receive AR services in the public and private sectors. We hope that by alleviating people's financial burden, we can encourage couples facing difficulties in conceiving to seek such services. We need to amend, therefore, the Inland Revenue Ordinance. The Health Bureau last year consulted the panel on health services on the legislative framework for this bill, and we got the support from members. And last year, we also tabled this bill to the LegCo. Now I'm going to elaborate on the details of the bill. We suggest that based on the current Human Reproductive Technologies Ordinance, we amend the existing legislation to help infertile couples who will, under this bill, enjoy tax deductions. There are two groups of beneficiaries. First, infertile couples or persons under specified circumstances. Specified circumstances include couples permitted to receive sex selection of embryos under the conditions to avoid certain sex-linked diseases. They also include those who receive RT procedures even after they are out of the marriage. The second group of beneficiaries include cancer patients or any other patients who may be rendered infertile as a result of chemotherapy, radiotherapy, or surgery or other medical treatment. That means those who receive AR services because of medical reasons will enjoy tax deduction. Infertility can be because of various reasons. It could be due to the male problem or female problem. As females give birth at a later age, they may encounter infertility problems, and there are people who will be eligible to enjoy the tax deduction. As for those who receive AR services for non-medical reasons, that is, those who do not have infertility issues, if they receive gamete freezing services, they will not be entitled to the tax concessions. Many young women nowadays opt for gamete freezing services so that they can use the gamete later to delay their childbearing plans. We want to emphasize that gamete freezing services cannot change the reproductive functions of females. Even with gametes or oocytes, females may not be able to get pregnant. Also, many people neglect the fact that when receiving gamete services, they may be subject to risks of invasive procedures. They also neglect the risk caused to females who give birth at a high age as well as their babies. As at the end of 2023, licensed centers under the Council on Human Reproductive Technology, about 20,000 eggs were frozen. And for those, only 50 cases used those frozen gametes, and only 7 females ended up achieving pregnancy using those frozen gametes. From these statistics, we see that it is not cost-effective to include gamete obtaining services under this bill, and it does not align with the legislative intent. People may opt to have their gametes frozen because of personal reasons. However, we do not encourage invasive procedures with risks, because this may cause them to miss their best childbearing years. That's why these services will not be included under this measure. In relation to the services which are licensed by the Council on Human Reproductive Technology, these services will be included in the scope of qualifying AR services, including the handling, storing, and disposing of gametes or embryo used or intended to be used in connection with an RT procedure. And these services should be referred by doctors or medical practitioners. And all directly related expenses paid for the qualifying AR services, including drugs, consultation fees, and so on, will be included under this scheme. Also, the deduction abides by the general tax deduction rules. Taxpayers can, based on the expenses they pay for the services, get deduction. The maximum amount allowable to a person for a year of assessment is $100,000. And the amount of deduction allowable to a married person or the person's spouse or both of them is the amount of expenses paid in the year of assessment, or the deduction ceiling of $100,000. The expenses which have been refunded or reimbursed are not allowable. To facilitate the claim for the tax deduction, a non-statutory standard form of proof for qualifying AR service expenses will be issued. The proof should be signed by the medical practitioner who holds clinical responsibility of the relevant RT procedure, certifying the date and amount of qualifying expenses paid for the services. The IRD may ask taxpayers to provide such proof in order to encourage people to form families and have children, I hope members will support this bill. I so submit. Thank you, Madam Chair. Thank you, Under Secretary. I now invite members to refer to the letters issued by the legal advisor to the administration. The administration said they will provide a response later on. If there are no particular views, we will first discuss the policy matters in this meeting. Members who would like to speak, please press the Request to Speak button. 4 minutes for each member. We should have plenty of time today. I'll give 4 minutes to each member, questions and answers inclusive. They will speak in the following order: Mr. Chen Pui-leung, Ms. Nixie Lam, Dr. Tan Yue-heng, Mr. Benson Look, Professor Chen Wing-kwong, Mr. Kenneth Lau, Mr. Kenneth Leung, and Mr. Kwok Wai-keung. Mr. Chen Pui-leung will go first. Thank you, Madam Chair. I support this tax deduction measure. We are facing a low birth rate, and we should encourage fertility as a solution. In relation to this tax deduction measure, for taxpayers who manage to achieve pregnancy after receiving the relevant AR services, will the baby born be able to enjoy tax deduction? We're currently facing a low birth rate, so we want to encourage people to give birth. Say if the taxpayers got the AR services, but they do not give birth to the babies in Hong Kong, would that be a waste? Also, there's a tax ceiling of $100,000. Based on what did you set this ceiling? Is this tax ceiling, deduction ceiling high enough? Say a person may receive AR services a couple times a year. I'm just wondering if $100,000 of tax deduction ceiling would be enough. It doesn't matter whether the taxpayers will achieve pregnancy after receiving the AR services. That means whether pregnancy is successful or not, it would not affect the tax deduction. And whether the babies will be born in Hong Kong will not affect the entitlement to tax deductions either. For infertility couples, they will enjoy tax deduction if they receive AR services. They may need to attend consultations a couple times. They have to return to hospitals very often because they need to have several embryos. So it is not likely that people will go abroad to give birth within the 32-week cycle. We looked at the cost of AR services in the private sector, and we believe the $100,000 ceiling would be enough to cover that.
If there are no follow-up questions, let's turn to Ms. Nixie Lam. Thank you, Madam Chair. I thank the government for being responsive. The money won't be enough. But we're making good progress by starting with nothing, and now we're offering something. We're taking a multi-pronged approach to raise awareness of this matter. I get it. Our finances are strained. But there are public aspirations. People say the tax break of $100,000 is on the low side. People can save maybe just a few $1,000s or somewhere like $17,000, depending on their income levels. So when the government is more at ease with its finances, can we increase the level of tax break? Just then, we heard about people rendered infertile because of chemotherapy or radiotherapy or other surgeries. Now, there are other medical treatments that may affect people's ability to conceive in the future. Say, when someone has a gynecological condition with the uterus, when you have the surgery performed, the ovary is affected, and that will affect the number of eggs in that woman. So can we cover that sort of surgery too? It's not just about chemotherapy, radiotherapy. There are other conditions that may affect people's ability to conceive. Can we also cover those people as long as they're in childbearing age? Where do we draw the line? Now, on how infertility is defined, how do we define it? Is it defined as failure to conceive after trying for 1 year? So how do we define it? Thank you. There are 3 questions. First, the tax breaks. So we can consider adjusting the limit, but that will have to be saved for later. Now, on the impact on the ability to conceive, this will require a clinical judgment, and that will involve a doctor who will have to make a judgment. As for the cases mentioned by the member, most of them will not affect the ability to have children as long as the condition is benign. Each doctor confronted with such a case will make a clinical judgment. Now, for this bill, we have a broad scope on what's covered. It's not just cancer. So that will require a doctor's clinical judgment in what's covered. So for that gynecologist, is it okay for a letter from the gynecologist to be enough proof for AR? That will require a discussion between the gynecologist and the woman. First of all, the doctor must talk to the patient. We must approach the matter on a case-by-case basis. The same condition may affect the ability to conceive in only some patients. Now, on how we define infertility, say you have a married couple, they try for a year and they fail, that will count as infertility. Any follow-up questions? Dr. Tan Yueheng. Thank you, Madam Chair. For this proposal, we are talking about a cap of $100,000 each year. So it's not that we're giving this amount or granting the tax break for each successful case. So the first year the couple may fail, they get $100,000 in tax breaks. The second year the couple tries again. In theory, that couple can benefit from the tax break again. So for the same couple, they may benefit from tax breaks amounting to $200,000 or $300,000. Is that the case? Now, my second question is, this tax break will cover to legally married couples, couples who are infertile. Do we only cover couples of a certain age? Do we only cover couples of a childbearing age? Do we also cover older couples? We can give some thought to covering older couples. There was abuse with different kinds of tax breaks. So for this particular proposal, how do we guard against abuse? What measures will be in place? Say, will we have spot checks, verification? Will we be checking the certificate signed by doctors to guard against abuse for this proposal? Thank you. Over to you, Undersecretary. Dr. Tan is right. For each couple, they get tax breaks up to $100,000 each year. If they fail the first year, they can try the second year, and in both years, they will qualify for the tax breaks. As long as the couple is legally married, there are no age limits. But for people going for 8-hour services at a public institution, there are age limits. No such restrictions apply in a private institution. It doesn't matter which age that couple is in. Now, the third question has to do with guarding against abuse, how we do that. That's why we propose a particular form. The medical practitioner of a licensed institution will have to fill out the form. That doctor will have the expertise. The doctor will fill out the form only when they're sure that service is given to an infertile couple. And if there is abuse, we can do something about the licensing. We also ask the public to keep their proof because the IRD can ask people for that proof for spot checks. Dr. Tan has a follow-up question. Follow-up question for the first point. Now, for people to conceive, they may need to try twice or thrice. So we're talking about 1,800 couples each year in terms of the treatment cycles, because public institutions will increase the treatment cycles. So we don't know how much it will cost in total, because the same couple may end up benefiting from $100,000, $200,000, or $300,000 in tax breaks over the years. So it's $100,000 in tax breaks for each year of assessment. Success or not, the couple can qualify for the $100,000 in tax breaks. We have calculated how much tax we are foregoing. Now, we're estimating that 6,600 taxpayers may qualify, and that means we're foregoing $50 million. So it's not like you only get to try once, and if you fail, you don't get the tax breaks again. Mr. Benson Look. Thank you, Madam Deputy, or Madam Chair. The government is making an effort to address the low birth rate. We have a package of measures. Now we rolled out the newborn baby bonus. Now we're offering the tax breaks for assisted reproduction treatment. The demand for such services at public and private institutions is keen. As the paper says, private institutions offer such services at hundreds of thousands of dollars. I support giving assistance to couples accessing those services. Now, I want to focus on the cost implications and the benefits. Now, the newborn baby bonus costs $640 million now. Let's look at the figures. 2024, 2023, of course, many factors are at play behind the birth rate, but the birth rate rose by roughly 5.5%. Now, for this tax break, we are foregoing $51 million. 6,600 taxpayers would benefit. So my question for the Bureau is, so apart from couples now accessing the 8-hour services now, will we be drawing couples who are not now using the services but may be drawn to these services as a result of the tax break? And what implications will this proposal have for birth rates, or will we see a similar level of birth rates in the future? Undersecretary. Thank you, Madam Chair. Mr. Lok raised great questions. The proposal here is to give financial assistance to couples accessing AR services. On whether we can boost the birth rate with this measure, I say this. Many factors are at play, many considerations are involved. It's not just about the tax break. People have to think about the upbringing of the child. So even with the tax breaks for AR services, even with the $100,000 in tax breaks, we're giving help to ease the financial burden on infertile couples. The implication for birth rates will be limited. So even when we step up the support for couples accessing AR services, the boost to the birth rate will be limited. Professor Chen Kwang, I support tax breaks for couples seeking medical services for childbearing. Now, I have some questions for the bill. Chinese medicine can make a real difference in treating infertility. Local and overseas literature shows Chinese medicine intervention can dramatically improve the success rate of IVF. For infertile couples, they access CM services. But the bill here says people can only turn to licensed institutions, licensed by the Council on Human Reproductive Services. Only services incurred at those institutions can qualify for the tax breaks. This year, we will see the opening of the first Chinese medicine service hospital. Even at that hospital, the services offered there will not be covered by this tax break. I believe the government neglected the role CM can play in treating infertility. And the government fails to live up to the expectations of people. Since we want to encourage childbearing, why not cover CM AR services under this tax break? And why are we not doing this? Undersecretary, we believe CM can play a role in helping women before pregnancy and after giving birth. CM services are not covered under this bill. That's not to say we don't believe or we neglect or we dismiss CM services. Even in Western medicine, there are unlicensed institutions. We don't cover those institutions in this proposal. People may turn to a gynecologist, but that gynecologist works at an unlicensed institution. In that case, the tax break does not apply. What we are giving is help to couples accessing services at licensed institutions. Now, what if your licensed institution hires CM practitioners or the institutions refer people to CM practitioners? Now, as long as the doctor who signs the certificate with the licensed institution signs it, then it's fine. Mr. Kenneth Lau. Thank you, Madam Chair. AR services are costly at private institutions. This bill here is to help infertile couples access AR services. The tax break is up to $100,000 a year. I support this because this measure can ease the financial burden on those couples so that they can access the services. Now, the tax breaks will not cover people who are not infertile or who don't have other medical conditions preventing them from conceiving. That's to guard against abuse. I support that. But more broadly, we need broader policies in childcare, housing, healthcare to create a better environment for people to have children, and that would better achieve the goal of encouraging childbearing. Now, I turn to my questions. The government's estimate is that 6,600 taxpayers will benefit each year. The Family Planning Association says 1 in 6 couples in Hong Kong are infertile. So, in the years to come, will we see more and more people requiring AR services? Do we have enough capacity at the local licensed private institutions? Can they cope? We will need to cover, that is, will non-local institutions need to get involved to provide those services, such as those in the GBA.
個問題
We cannot only look at infertility issues from a medical perspective. Mr. Lau is correct that a set of population policies should be available, including education and housing measures. Currently, 1 out of 6 couples in Hong Kong is infertile. We have to see whether late marriage will continue to be a trend in Hong Kong and whether women in Hong Kong will choose to give birth at a late age. If it is the trend, then of course we will see a more serious infertility issue in Hong Kong. Currently, we don't have enough service capacity. Currently in Hong Kong, there are only 11 doctors with the qualifications to treat infertility problems. So we lack the service capacity. We have to actively train up a new generation of doctors to cope with the service demand. There are other illnesses or diseases that have to be treated, however. So we have to look at the manpower in a holistic manner. The Health Bureau will have to formulate different measures to increase the number of healthcare workers in Hong Kong so that we can provide better services to people. Any follow-up questions? No. Mr. Kenneth Leung. Thank you, Madam Chair. Some members mentioned that we have to look into how we can cope with the population problem. This is a great challenge for us. In the 2023 policy address, there is a series of measures to address this. I agree that this tax break will not discourage people to give birth. Instead, it will help encourage childbearing for those who wish to have children. After the tax break is rolled out, will the government roll out different publicity campaigns to tell people what kind of help they can seek and how AR services can help them? Some people, they may have tried AR services and they may feel discouraged, or some, they do not know that they can actually seek such services. So will there be more promotion so that people who wish to have children can get help in a timely manner? Just now, members asked whether there would be any collaboration with the GBA. The Hong Kong U Hospital in Shenzhen could perhaps be included in this scheme. There will be more and more mainland hospitals that will work with the Hong Kong government. I believe these could be included in the scheme as well. Undersecretary, education and promotion are crucial. At the primary healthcare settings, we talk about life course. People at different ages, they have to learn about their health conditions. A woman or a man at their childbearing age, you have to tell them that there is a life cycle. So we will step up publicity so that people are aware of that and that they should seek help as soon as possible if they need to. As for collaboration with the GBA, we think what is more urgent is that we need to boost the capacity of local doctors to help treat infertility. However, it's quite competitive. Doctors may not opt to provide such services. We won't rule out the option of seeking collaboration with the GBA, however. Mr. Kwok Wai-keung. Thank you, Madam Chair. It is, of course, good that the government is offering help to couples who need 8-hour services. The government is increasing the number of service quotas and also rolling out the tax break. These are all great. I have the following questions. First, say a taxpayer spends more than $100,000 on 8-hour services, say $200,000 or $300,000. Would the tax deduction ceiling be still $100,000 a year? I heard that a married couple will be entitled to a deduction ceiling of $100,000 per year. Also, will this tax deduction measure be applicable to surrogacy services? Say a doctor gives a couple the advice that they should not have the baby or conceive the baby themselves. Would surrogacy moms be included in this scheme? Also, a doctor emailed me with this question. The doctor got an inquiry from a woman who sought 8-hour services overseas, but that woman had to receive regular body check in Hong Kong. And it is only when she is notified that she will go abroad to get the embryos. Under the current employment ordinance, women can get maternity leave for examination or body checks. The doctor said he gave leaves to that woman, but he wasn't sure if this is legitimate. So he gave the woman 2 to 3 days of leave every 6 months for prenatal checks. Would they be included? That woman was under great pressure because she had to receive body checks regularly, and she was afraid that this would affect her job. So I would like to have the administration clarify this. Undersecretary, the amount of deduction allowable for a married person is $100,000 per year. Currently, there is no licensed institutions in Hong Kong that could provide surrogacy services. Say an institution applies for a license in the future to provide surrogacy services, relevant expenses would be subject to tax deduction. As for your other question, I'm not afraid I can give you a 100% accurate answer. A doctor can issue sick leave certificate or attendance certificate. So I'll have to clarify with you about this. Can I have a follow-up question? Yes. So the tax break is $100,000 per year for a married couple. Say a service spans a year. That means in the following year, the married couple will be subject to tax deduction again if they continue to receive the AR services, correct? Dr. David Lam, a couple of questions. This tax break will not benefit only people with the Hong Kong ID card, is that right? All taxpayers who pay salary tax or personal assessment will be subject to this tax deduction, is that right? Also, when will the tax be deducted? According to the paper, the year the tax is deducted may not be the same as the year the taxpayer receives the AR services. Say the institution that provides AR services charges the taxpayer in advance. Will there be a loophole? Also, we have the voluntary health insurance scheme. And most insurance plans do not cover AR services. You have to prove that you are infertile, or that you have the medical needs to seek AR services, or that you are receiving chemotherapy that render you infertile. It is only under such circumstances that you will enjoy a tax break. So my question is, when you review the voluntary health insurance scheme, will you cover such services as well? Undersecretary, we will include taxpayers who are non-Hong Kong residents. They will be able to enjoy the tax deduction. Also, we believe doctors in licensed institutions, they will not forge receipts or proofs just to enjoy the tax break. Also, the IRD would do sampling checks, asking taxpayers to provide the proof to see when the receipt is issued. Every year, taxpayers will be subject to this tax deduction of $100,000. We have the cutoff date. I believe doctors will not split the bill into four for people to be able to enjoy tax breaks. If there is such a case, I believe it will be referred to the medical council. On the point about the voluntary health insurance scheme, when we review the scheme, we will consider including more items under the scheme. Yes, we will review VHIS. We will consider adding more items into the scheme. I'm speaking for the first round. I welcome this tax deduction proposal. It may not stimulate the birth rate significantly. However, I believe at least this will help the government send out the message that we care about the birth rate in Hong Kong. The administration mentioned that it wants people to seek help if they are infertile. In relation to tax deduction, have you considered the practices in Japan or Korea? Will you consider offering tax deductions on a progressive basis? For those who seek IVF treatment at a younger age, they will get a higher tax break. Have you considered this proposal to encourage childbearing? As you know, some young couples, they may have tried for a year or two to conceive, but they do not try actively. They may wait for another 1 year or two. will you consider rolling out stimulus measures like providing tax deductions on a progressive basis? We don't think this will encourage infertile couple to seek more AR services. Instead, this serves as a support. Will this encourage younger people to seek IVF treatment, for example? We aren't sure about that. Instead, we think that we should educate couples to seek AR services as early as possible. We also want to reduce the waiting time for such services. We know that the waiting time has been reduced for services provided by the hospital authority. The waiting time has been reduced from 12 months to 7 months. We want to make it easier for people to have access to AR services so that they can get medical treatment as early as possible. We want to educate young people so that they are aware of what AR services are available, and also this may help boost the birth rate. We want to tell them that they should seek services as early as possible.
可以之後
If you don't have the details at hand, you can give me the information later. Does the government have the figures on the age of infertile couples when they access medical services? Now we're talking about women seeking AR services. Most of them are aged 36 to 40. For younger ones, say those aged 31 to 35, that's the second largest age group. Many infertile couples go for AR services before 40. And for other age groups, they are smaller in number. Some members wish to speak for the second round. We have time, so let's do the second round. Ms. Nixie Lam. I have a question about the form. Clinics wonder what kind of documents they have to keep. So the new regime will kick in after the 1st of April. So are clinics supposed to keep the receipt, invoices, and what other documents they have to keep? They want to know. I have also checked with the government by other means whether a standard form can be provided. And all that I was told was that the receipts have to be kept, and that's all there is. Some clinics may wonder what documents they have to keep. Clarity over this point will help those clinics and the couples. Now, education, I agree. IVF does not really solve the problem. We have to teach people from a young age about fertility. Sex education now is simply about intercourse. We don't teach kids about bodily functions. So there's an information gap. By the time people reach their childbearing age, they struggle, and that's too late. People try to have kids in their 30s in Hong Kong now. So the government can do a better job in education. The maternal and child health centers can play a role. Let's give people more information. Young couples don't look up government websites. So the government should try Instagram, Threads. Even Facebook is for people in their 40s. So we have to find new ways to get the message across to young potential parents so that they know how it works early on. Thank you. Now on the information that clinics should keep. The Department of Health, Dr. Leung, will address that question. On education, I agree with Ms. Nixie Lam. Education matters. We need a change in public health. It will take more than just putting up posters. We need a change, and we will look into that. Thank you. Now over to Dr. Leung. Dr. Raymond Leung. Last year, we consulted the panel on health services on this bill. Subsequently, our department put out a press release. There was also a letter from the Council on Human Reproductive Services. So we announced the timeline for this proposal. So clinics have been made aware of the arrangements, such as the forms to be filled, so the clinics know what to do. We are consulting the industry about the almost final copy of the form. So can we get a timetable? When will the form be available? Once this bill is passed, that form will be circulated with institutions. How much? So how long after? So right after the passage. So apart from the receipts, what else do the institutions have to keep? The medical records. So no other members wish to speak on policy matters. So if we have no further questions on policy, I now invite the department to walk us through the clauses. So we will first look at the Chinese text. So can we first invite the government to walk us through clause by clause? Members may also refer to the Chinese copy as well as the marked up copy, and that's CB bracket 3 1078 stroke 2024 bracket 03. Mr. Lee will walk us through the bill. Mr. Liu Lee, thank you. Why don't we start with the blue bill? There's a principle we want to bring to members' attention. So we are amending the Inland Revenue Ordinance. There's a separate ordinance regulating assisted reproductive services. That's CAP 561, which is beyond the scope of today's discussion. CAP 561, which is the Human Reproductive Technology Ordinance, HRTO. That ordinance sets out details about licensing, who can access the services. That ordinance has been in place for many years. So our amendment today simply incorporates certain provisions from CAP 561 into the Inland Revenue Ordinance, such that people accessing the services under CAP 561 can qualify for tax breaks. So shortly, we will be bringing up many concepts from CAP 561. I don't have a copy of the HRTO here, so I will be briefly explaining what those concepts are. So now let's get right into the clauses. This is a bill to amend the Inland Revenue Ordinance to introduce a new concessionary deduction concerning salaries tax and tax under personal assessment that may be allowed for assisted reproductive services expenses and to provide for related matters enacted by the Legislative Council. This ordinance may be cited as the Inland Revenue Amendment Tax Deductions for Assisted Reproductive Services Expenses, Ordinance 2024. Now, first, we are looking at the changes to sections 3 to 10. So, clause 3, part 4, A, division 9 added. Now let's look at C2559 in the English version, and this is the expenses. The scope, starting from the 1st of April 2024, that year of assessment and all subsequent years of assessment will be covered by this tax break. So for people accessing AR services in those years, please keep your receipts, and then you can request arrangements to be made to their provisional taxes. Now, 26ZE interpretation. Reproductive technology procedure, or RT procedure. This means a reproductive technology procedure as defined by Section 2, Subsection 1 of CAP 561. So, they mean RT procedures involving surgeries or internal medical procedures. They may recover artificial insemination, obtaining gametes, handling and processing gametes, among other procedures. And also, gender selection achieved or intended to be achieved by means of a procedure which falls within this definition. Now let's return to the bill here. Qualifying AR service, and that's detailed under Section 26ZF. Now, the expenses. They mean any expenses payable for receiving a qualifying AR service. There's a code, and that has the meaning given by Section 2, Subsection 1 of CAP 561. Under CAP 561, there's the Council on Human Reproductive Services. That council manages the licensing of such services. Licensed institutions can provide AR procedures based on their license. So that code is prepared by the council, and that's explained under Sections 8 and 9 of the HRTO. So it's about guidelines for the placing of an embryo in a woman, and that code is publicly available. Now, next we come to gamete obtaining procedure. Again, we return to CAP 561. One form of RT procedure is the obtaining of gametes. It's simply about obtaining. It has nothing to do with embryos. We're simply obtaining the gametes. Next, recipient. In relation to an RT procedure or service means the person to whom the procedure or service is to be provided, and receive is to be construed accordingly. Now, CAP 561, and that's the ordinance I was referring to, HRTO. CAP 561 means the Human Reproductive Technology Ordinance read together with the code. The legal advisor wrote to us with a question whether we do need to put the code in the definition. There's a policy consideration behind that. CAP 561 governs the provision of human reproductive services. The code covers the services provided by the institutions. Now, to spell out who can access RT procedures, you get a full picture when you read CAP 561 in conjunction with the code. There is room for improvement in the drafting because there appears to be some kind of circular referencing in the phrasing. So we thank the legal advisor for spotting this matter. So we will move a committee stage amendment to fix it, to give greater clarity to the phrasing. So we will be clarifying the point by rephrasing the interpretation. Now, 26ZE. Now, for the purposes of this division, if CAP 561 does not prohibit an RT procedure, and be it the person is the person or one of the persons mentioned in paragraph 2A2 of the definition of surrogate mother, insofar as the surrogacy arrangement is concerned, and 3, a qualifying AR service is to be provided. This addresses the point about a surrogate mother raised by Mr. Kwok. So this provision here anticipates a situation. So say in the future, you have a licensed institution offering surrogacy. The tax break will apply to the commissioning couple, not the surrogate mother. Even though the surrogate mother gives birth to the child, she will not qualify for the tax break. So if we're all good, I will carry on.
26 says F, meaning of a qualifying AR service. Let's talk about what it means by service. It means RT procedures. As mentioned, RT procedure covers IVF treatment, artificial insemination by husband, etc. All these services require licenses before being provided. And the relevant activities are covered in CAP 561. They include study on embryos as well as storage as well as disposal of embryos used or intended to be used for AR services. And a license will be required to provide these services as well as to dispose of gametes or embryos. Currently, there are 4 types of licenses. They include treatment license as well as artificial insemination by husband license. 13 private institutions as well as 13 public as well as 27 private institutions are eligible to offer such services. So here it touches on different types of licenses. A service of providing either of the following RT procedures pursuant to an RT license. 1, an RT procedure, and 2, a gametes obtaining procedure. You may have questions about this, but let me touch on bracket B first. C2563. It touches on the handling, storing, or disposal of gametes or an embryo. In order to be licensed to offer these services or to carry out these activities, you'll have to meet the following requirements. The conditions are as follows: that CAP 561 does not prohibit an RT procedure other than a gametes obtaining procedure to be provided to the recipient of the service. B, that the recipient of the service is a cancer patient or any other patient who may be rendered infertile as a result of chemotherapy or other medical treatment. You have to look at these 2 subclauses together. It is only institutions or only taxpayers that have access to the licensed services can enjoy the tax break. CAP 561 as well as the code do not prohibit anyone to have access to an RT procedure. Under CAP 561, gametes obtaining procedure can be accessed by an infertile couple or a fertile couple. Say a single male can opt to freeze his sperms even he is not infertile. Also, a fertile female can choose to have her gametes frozen. However, under CAP 561, IVF treatment or artificial insemination by husband services, these aren't gametes obtaining procedures. These are RT procedures other than a gametes obtaining procedure. Fertile couples are prohibited to access these procedures. So if you want to access a gametes obtaining procedure, you have to be an infertile person according to CAP 561. There are some exceptions. CAP 561 allows fertile couples to receive IVF treatment or artificial insemination by husband under the following circumstances. Under Section 15(3) of CAP 561, there are some AR services that would not harm the embryo. Also, if the doctor thinks it is necessary, then under these circumstances, even fertile couples can have access to these AR services. Also, Section 15(7) of CAP 561 says if a person is still in a marriage when receiving the RT procedure and that the embryo is already placed in the body of a woman who is a party to a marriage, then you can carry on with the procedure if you get divorced after the embryo is placed in the body. We can now go back to 26 at F1(2). So you can enjoy tax breaks even for a gametes obtaining procedure, but you have to be infertile as well as having the specified circumstances mentioned above. If you're simply an infertile person, say a male who is infertile and chooses to freeze his sperms, he will not be able to enjoy the tax break. For procedures other than the gametes obtaining procedures that are regulated by CAP 561, and you can only have access to these procedures if you are an infertile couple. So it sets out who can enjoy the tax breaks here. Any questions from members? Feel free to raise your questions. No? All right, please continue. Thank you, Madam Chair. Now we move on to C2563, bracket 3. For the purposes of subsection bracket 1A, subject to subsection 4, a medical service is related to an RT procedure falling within subsection 1A, 1 or 2. If it is a medical service that A is directly related to the qualifying procedure, B is provided before the qualifying procedure is to be provided, so long as CAP 561 does not prohibit an RT procedure to be provided to the recipient of the medical service. So as long as the medical services are directly linked to the RT procedure concerned, then you will be able to enjoy the tax break. However, if you look at bracket C here, there's another restriction. You will need a registered medical practitioner to refer you to the relevant procedure. It is not any registered medical practitioner can do that. registered medical practitioner will have to hold the clinical responsibility for the recipient of the qualifying procedure. According to the code, it is not that all RT procedures require a registered specialist to provide such services. For example, for procedures that consist of lower risk, for example, artificial insemination by husband, they do not have to be provided by a registered specialist. However, the doctor will have to hold clinical responsibility. He will be making the clinical judgment of what kind of procedures are needed. So we have taken into consideration the institutions in both the public and private sector that offers an RT procedure. In the public sector, such services are usually offered by a team. That's why we say a registered doctor who holds any clinical responsibility here. So even if the doctor is changed to someone else in the team, then the person will still fall under this definition. Can you speak closer to the mic, please, Mr. Lee? All right. Yes, Mr. Chen Pui-Lang. The first line of bracket 3B1, it says, before the qualifying procedure is to be provided. I don't quite understand this line. What is it trying to express here? A qualifying procedure is an AR procedure, an RT procedure, or a gametes obtaining procedure. Before the procedure is to be provided, you should have got a diagnosis saying that you need such procedure. You may need to have a hormonal injection. These procedures are not regarded as an RT procedure. However, it is a medical procedure. A doctor may find it necessary to carry out such medical procedures. And in order for these medical procedures to be included, we have subclause 3B1 here. And if these medical procedures are required, then you will still be able to enjoy the tax break. Does it include CM service? Medical service, according to this bill, include counseling service. Counseling service is quite commonly needed. However, it doesn't exclude CM service here, based on how it is drafted. So as long as the procedure meets the conditions of subclause 3, that is, it is directly related to the qualifying procedure and that it is offered by a registered doctor, then it would fall under the scope. Yes, Dr. David Lam. I would like to ask about the correlation between B1, 2, and 3. So you need 1 or 2 and 2 and 3. Or is it that 1 alone can stand? Well, you definitely need to meet the condition of 3A. For 3B, it depends on when the procedure is to be provided. It could be before the qualifying procedure. So C is also a compulsory condition. So it could be A, B1, and C, or A, B2, and C, such combinations. According to bracket C, it says registered medical practitioner who holds any clinical responsibility for the recipient of the qualifying procedure. We often talk about duty of care. However, the term duty of care is not used here. Instead, clinical responsibility is used. Are they the same?
係，
多謝議
李生。
員問題。
Madam Chair, now here we mention clinical responsibility. The legislative intent is that this doctor needs to be part of the procedure. The doctor has to be clinically responsible for the procedure. We are specifying the doctor instead of specifying the standard of care. We're pointing to the doctor who is involved in that procedure rather than specifying the standard of care. And we're talking about this particular doctor. This doctor directs the medical services or refers the patient to a service, and only then will the service qualify for the tax break. Now, I'm not referring to the standard of care. Court cases usually refer to the duty of care instead of clinical responsibility. I think the meaning is the same, but I just wonder if there's any reason behind the choice of word. I'm wondering if duty of care is a bit too broad. Here, we're simply talking about the responsibility, the clinical responsibility for a specific procedure. But when you say duty of care, you can refer to a wider range of procedures. Here, we're simply talking about a specific procedure. Whereas in the duty of care, you can refer to some kind of general health conditions of the patient. I want to follow up on a point from Dr. David Lam. He will ask the question about 3A, B1, or 2, and C. 1 does not appear to be necessary. That is 3B1. So can I invite my colleague from the Department of Justice about the drafting convention? So 3. Now under subsection 3, there are 3 items, A, B, and C. A, directly related. B, it's about the service has to be provided before, during, or after. And C, it's about referral. Now B is one of the 3 requirements. Under B, there are Roman numerals 1 and 2. The or may be causing the confusion. 3B2, we're saying the service provided during or after the procedure is provided. It wouldn't have made sense if I put and instead of or after 3B1. So in that case, shouldn't you put the and in a separate line instead of right after 3B2? Now, our drafting convention is to put the connector, in this case and, after the last bit of B. So A semicolon, B semicolon, and C. Let's move on. Mr. Liu Li. Now, C2565 in the English version, bracket 4, for the purposes of subsection 3, if gametes or an embryo is placed in the body of a woman pursuant to a qualifying procedure and subsequently the establishment, a clinical pregnancy of the woman is ascertained, a medical service provided to the woman after the ascertainment is not related to the qualifying procedure. So we mentioned under bracket 3, services provided after the procedure. Those services still qualify, but at some point, those services cease to qualify. That's where 4 comes in. So pregnancy has been ascertained. That means the RT procedure has ended and the woman managed to conceive. From that point onwards, no medical services will qualify for the tax break. So it's about that cutoff point in time. So here it says, or the failure to establish. Now let's move on. Bracket 5. RT licensees. They mean any of the following licensees: A, an AIH license; B, a storage license; C, a treatment license. Now we only have A and C. No licensed institution has a storage license yet. Now, on registered medical practitioner, it has the meaning given by Section 2, subsection 1 of the Medical Registration Ordinance, Cap 161. Store, in relation to gametes or an embryo, means to store the gametes or embryo within the meaning of Cap 561. Storage under Cap 561 includes preservation, whether under a low temperature or in other conditions. So that's the freezing of gametes or an embryo. Medical services include counseling services. That's been covered. Moving on to the next page, we come to Clause 26ZG. So who can pay for such services? Now, service expenses paid during a year of assessment. I'm sorry, Mr. Liu Li. A question has a member, Dr. David Lam. When Mr. Li answered a question from Professor Chen Mingguang about whether CM practitioners are excluded, I'm looking at 3A, and says directly related to the qualifying procedure, but then 3C says the service has to be provided, prescribed, or registered by a registered medical practitioner. But then a registered medical practitioner is defined as someone under Medical Registration Ordinance, Cap 161. So effectively, you are ruling out CM practitioners. Indeed, we do not accept referral from CM practitioners. So we look at the certificate signed by the registered medical practitioner of a licensed institution. So the referral has to come from a medical practitioner to a CM practitioner. A CM practitioner cannot refer someone to a service. No follow-up questions? Let's move on. So we were at 26ZG bracket 1. So we're talking about qualifying AR expenses paid during a year of assessment. Now, the person who pays such expenses, it has to be the person's spouse, or the person and the person's spouse. And these expenses were paid for AR services received by the person's spouse, or the person and the person's spouse. The maximum deduction allowable is $100,000 per year. And we will come to that, and that's Schedule 3H. The legal advisor wrote to us with a question about this point, and it's about 1A. And it's about the person's spouse not being a spouse living apart from the person. And why the discrepancy between A2 and B2? Because A2 refers to spouse not being a spouse living apart, whereas this is absent under B2. Now, the reason is this. This proposal is to incorporate provisions under Cap 561 into the Inland Revenue Ordinance. A, or rather 1A, is about who pays. The same requirement applies to the VHIS and the deferred annuity. This is in line with the existing arrangement under the IRO. B, on the contrary, is about the services, not the money. And this has to do with Cap 561 instead. Cap 561 does not require a spouse receiving the AR procedure to cohabit with the person. That's why a spouse receiving the AR services does not have to cohabit with the person. And we do not propose to add such a restriction in this amendment because doing that would be shutting out some people. So there is no pre-existing restriction, and we see no reason to add such a restriction. Now we come to 26ZH, claim of deduction by married persons. Now for a deduction under Section 26ZG claimed by married person or the person's spouse or both of them, this provision will apply. Now for expenses paid, deduction is allowed for the following persons: the married person, the person's spouse, and both this person and their spouse. Here again, you don't see the requirement about cohabitation. This is in line with the IRO. But the cap applies all the same for a given year of assessment under Schedule 3H. Now, bracket 3. Now, what if someone has more than one marriage in a year of assessment? The same cap of $100,000 applies. Dr. David Lam. The timing of the payment matters, but the time of incurring the expenses may be different from the time of payment. Tax is all about when you incur the expense. You buy something, but you pay next year. You may pay at different points in time for the same service. Why are we adopting this different approach here, something that's different from general tax and accounting arrangements? Now, on incurring an expense, that applies to profits tax. Now, for the salaries tax instead, we want to keep things simple for taxpayers. We look at the payment, the timing of the payment instead. When we check the receipts show when the payment is made. That keeps things simple for the taxpayer and the IRD. So we focus on the timing of the payment instead. Please continue, Mr. Lee, for bracket 4. Thank you, Madam Chair. C2569, the English version, bracket 4. If the Commissioner has reason to believe that the total deduction claimed by a person and the person's spouse for a year of assessment, if allowed, would be contrary to subsection 2 or 3, the Commissioner may, for ensuring that the total deduction allowed to them would accord with that subsection, allow an amount of deduction to each of them that is reasonable in the circumstances of the case. So say each person claims a deduction and each claim exceeds the cap. In that case, the Commissioner can adjust the actual deduction allowed to each person. Such provisions are in line with similar provisions under the IRO. They are nothing new. Now we'll come to bracket 5. If the Commissioner exercises the power under subsection 4, then A, the person may apply for an adjustment of the amount of deduction allowed to the person. B, the person's spouse may apply. And C, both the person and the person's spouse may apply. 6, the application has to be in writing. There's a 6-month window. That's 6B. Now, 7. Say these two people, the person and their spouse, reach an agreement, and the total amount is in line with the cap. The Commissioner can adjust the deduction. If no agreement is reached, the Commissioner also has the power to make a decision. So that's bracket 8 through 10. These are standard provisions. So shouldn't we have or instead? 1 or 2? If not, if 1 doesn't work.
我請律政司同事
I'll invite DOJ to explain. Sorry, which subclause are you referring to? Section 26, set H, bracket 7A12. Mr. Lee said if condition 1 is not met, then condition 2 would come into play. I believe these provisions are in line with those under the IRO. We made reference to the existing provisions concerning the general tax deduction rules. Bracket 7A1 and 2 both talk about the agreement. However, or is used after A2. Because if an agreement is not reached, then the Commissioner may step in. According to subsection 9, the Commissioner may adjust the amount of deduction all right. Let's move on to C2575, Section 26ZI, refund or reimbursement of qualifying AR service expenses paid. Bracket 1. This section applies if any qualifying AR service expenses paid during a year of assessment are refunded or reimbursed. The qualifying AR service expenses paid are taken to be reduced by the refunded amount or reimbursed amount. Some members asked whether this will be included in some future insurance plans under the voluntary health insurance scheme, or these can be an employee's benefit. When you claim tax deduction, you should take away the refunded amount or reimbursed amount. That means the taxpayer will not enjoy double benefits. Bracket 3. If the refund or reimbursement is made after a person claims a deduction in respect of the qualifying AR service expenses, the person must notify the Commissioner in writing of the refund or reimbursement within 3 months after the date of refund or reimbursement. And if the deduction has been allowed, then despite any time limit for making an additional assessment under Section 60, an assessor may, having regard to the reduction, make an additional assessment on the person under that section. Section 26ZJ, exercise of Commissioner's power. The Commissioner may exercise a power under this division in the way that the Commissioner, having regard only to the information then in the Commissioner's possession, considers appropriate. Let me pause here. If members do not have any questions, we should move on to the marked up copy, LC paper number CB bracket 3 1078/2024 bracket 03, because it will be hard for members to follow if we stick to the blue bill now. The marked up copy shows you the track changes. Page 0001 of the English copy. These are all technical amendments. Section 26ZE. If you go to page 2 bracket 4, the deduction under Section 26ZG, deduction for qualifying 8-hour service expenses allowable to that person not exceeding the amount specified in Schedule 3H for the relevant year of assessment. We have to add this subclause G before bracket 4. This is about the tax deduction arrangement. If you move on to page 14, before bracket 5, we have to add bracket G. The deduction under Section 26ZG, allowable to them not exceeding the amount specified in Schedule 3H. Section 63E, about holding over of payment of provisional salaries tax. We have to add bracket 2 here. We are adding bracket BH as well as BG and or BH. Page 22 of the English copy is about the penalty. If you fail to comply with the requirements, there will be consequences. So we are adding bracket CD. Fails to comply with Section 26I bracket 3 bracket A. It is about the reimbursement. Say if you've enjoyed an employee benefit, you have to report it within a time limit, and if you fail to do it, you'll be subject to a fine of level 3. Page 24 of the English copy, additional tax in certain cases. We're adding bracket CD here. The legal advisor raised a question about Section 80, page 22 of the English copy. Our legal advisor has a question. Thank you, Madam Chair. On Section 80, Bracket 2, we wrote to the administration and raised a couple of questions. We asked whether the new offense would be a strict liability offense. Would the administration give an explanation here, or will you provide a written reply afterwards? Thank you, Madam Chair. Thank you, Legal Advisor, for the question. We've talked to the DOJ. The Commissioner will not be aware of the refund or reimbursement unless the taxpayer reports it. So there is a liability on the taxpayer's part to report the refund or reimbursement. As to whether the proposed new offense will be a strict liability offense, it will not be a strict liability offense. If a taxpayer does not have any reasonable defense or excuse and fails to comply with the requirements, then it will be an offense. It is not a strict liability offense. And this aligns with Section 80, Bracket 2, CB and CC. I want to ask about the double benefits. I understand that insurance companies may make a refund to taxpayers. Say an employer or a company wants to encourage its employees to give birth and offers some kind of bonus. Will this provision discourage private companies or enterprises to roll out such bonuses? I understand that insurance company may make refunds. However, for subsidies or allowances rolled out by companies or to employees, will they fall under the scope? Because we do want to encourage childbearing. Let me read this out. 26(I) Bracket 1. It says any refunded or reimbursed services. Many private companies, they roll out bonuses for their employees. To encourage childbearing. And they will not be considered as a reimbursed amount. I'm not just talking about bonuses. As far as I understand, some foreign companies, they want to encourage the employees to use AR services. And if you use such services, the company would give you some form of subsidies or allowances. So are you disincentivizing private companies or enterprises to encourage childbearing? This might be a policy matter. You mean this will discourage companies or employers to roll out childbearing measures? From the perspective of a couple, the tax break will be $100,000. Say I get a service that cost $120,000 and I get a subsidy of $20,000 from the company. I will still get the tax break. If the company settles the entire bill, then the employee will be very happy. I don't think a small bonus would lead to a smaller tax break and discourage people to have children. Say I get a service that costs $120,000 and my company subsidizes the service and pays $60,000, I'll still get $60,000 of tax break. Well, if you don't get the benefits from the company, you'll get a full tax break.
稅人佢如果
In this case, say you have reimbursement. The person does not pay that money in the first place when a company pays part of the expenses. Take continuing education. Firms encourage their workers to seek continuous education. You also have reimbursement. In this case, the taxpayer will have to make adjustments in filing a tax return. As long as the conditions of the tax deduction are met, then the deduction can apply. So this is in line with the usual practice. So let's move on. 0022. Madam Chair. Page 24, additional tax in certain cases. So you have to include the information in tax returns. Now, page 25, bracket 4. When additional tax is assessed, we're adding the references. It's about giving notice. Page 28, 0028, and it's section 89, subsection 33. The new section, subsection 33. So Schedule 60 has effect in relation to a person liable to pay provisional salaries tax in respect of the year of assessment commencing on the 1st of April 2024. We will come to Schedule 60 in a moment. Page 29. Now, starting from the 2024 and 25 year of assessment, the cap on allowable deduction is $100,000 under column 3. Page 30, and that's Schedule 60. This applies to the current year of assessment. If someone is liable to pay provisional salaries tax, this taxpayer can apply to the Commissioner of Inland Revenue for part or the entire tax to be held over, and this is part of the transitional arrangement. So that's the arrangement for the current year of assessment. We put that in this schedule because this year of assessment is really coming to an end. That's why 2(3) says, or rather section 3 says applications are needed. The application must be made no later than the 28th day before the day by which the provisional salaries tax is to be paid, or the 14th day after the date of the notice for payment of provisional salaries tax under Section 63C, subsection 6. That's for people, taxpayers who wish to apply for the holding over of their salaries tax for this year of assessment. People have to apply to the IRD soon. After this bill is passed, if they want to hold over their salaries tax, so those taxpayers should file their application as soon as they can. So that's for the Chinese text. Questions about the Chinese text from members? If not, so can we invite our legal advisor to check if the English version tallies with the Chinese text? Thank you, Madam Chair. We have no other comments on the drafting and the legal points in the Chinese and English text. We wrote to the government with questions. We still have to wait for the government's reply to see if we have any follow-up questions, and then we will report the matter to members. So we will have to wait for the government's reply to the legal advisor's questions. Now, a question for members. Do we need an extra meeting for this bill? All good? So we don't need another meeting? No more questions? So since that's the case, we don't need another meeting. After the meeting, I will work with the Secretariat and the administration. we will work out the date for the resumption of the second reading debate and also the legislative timetable, and then I will let members know. Dr. David Lam. We agreed on inviting public submissions, and we still have to wait for the government's response. So we should all first look at the submissions and the government's reply to see if we have questions. We will circulate those papers among members, and then we decide when the bill can resume second reading debate. If there's no other business, I adjourn the meeting here. Thank you.